Court will call State versus Brooks, case number 21 CF 1848. May I have the appearances, please?
Good afternoon, Judge Sue Upper,
Leslie Basie and Zach Woodchow, all appearing for the state of Wisconsin.
Sir, state your name for the record, please.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments. Also, Your Honor, I would like to make an offer for my appeal, if I may.
I'll get to that momentarily. The record will reflect that the individual known to this court to be Darrell Brooks is appearing in person in custody. We are, of course, outside the presence of the jury today. Since they are not here, we are dealing with some housekeeping type of issues and other legal matters. So he is appearing today in jail attire. He is in custody. And it's my understanding, Mr. Brooks, that you were offered to appear in the suit, but chose to come to court in jail attire, which is fine. We're not in the presence of the jury. I just wanted to make a record of that.
I do not consent or identify by the name that you stated earlier. I want the record to reflect that, if I may.
The record will reflect. Thank you. All right, I know there was some filings, and I want to make sure the parties have copies of everything. Mr. Brooks, I know there was an inmate communication form filed, I believe earlier this morning, requesting 6 subpoenas as soon as possible. I instructed my staff to make sure ample copies of the subpoena forms were provided to you. I did receive verification that those were hand delivered. Did you receive those, sir?
No, I did not.
We'll provide additional copies. Again, it's my understanding those were hand delivered to the jail, and that the jail took care of that in the event that that latter part did not take place. Mr. Brooks, I believe you were requesting 6 subpoena forms. I'm going to have my clerk print out 10 so that you have ample copies, and when that is done and those are handed to you, I'll make a record of that.
Will we address the inmate communication form I sent about the...
I have a number of issues I need to address, so yes, we'll get to that.
You don't believe that that has that's an important issue that should be taken up before we continue any further in the proceedings?
I just want to make sure the state has a copy of what was forwarded first before we take that up. I'm not seeing it in the record yet, so I did a F5, so it'll refresh.
So the prosecution will receive a copy?
I believe one was printed now for them. It is in the record. And then I'm going to print off something as well. I don't know if it was already.
Your Honor, I respectfully would like to state for the record and would like the record to reflect that I believe that this is an issue that should be addressed at this point before we go any further.
Preparing to do that. I didn't say I wouldn't do that. So give me a minute. I have some documentation that I'd like to provide to the parties as well. And I want to confirm with Attorney Opper that you have now received a copy of that inmate communication form.
Yes, I have one in front of me, Judge. It's dated today's date, October 5, 2022.
Yes, dated today because I just learned of the protocol that I would be on as of today.
Can you print or make 2 copies, one for each party? All right, I'm gonna provide a document to the parties. It's a 5-page document. It is a document that was forwarded to me at my request by Monica Paz, our clerk of court, after receiving the inmate communication form from Mr. Brooks requesting an adjournment. For the reasons stated in that document, I thought it important that we all have before us the current county protocol related to COVID-19. And so this will be provided to the parties.
Now, I decline to accept that if I don't believe
Sir,
that it's
it will be placed on your table, but I will be referring to that today, so
Is
it's
it
been
law?
given to you.
Is it verified law, Your Honor?
Attorney Opper, do acknowledge that the COVID-19 illness reporting protocol was provided.
I respectfully object.
Yes, Judge.
Your Honor, I would like an answer to that question if I may. As I have not consented to or agreed to accept any paperwork that,
Sir, it's been
It's not
provided
okay.
to you. It's
So are you
something I'm gonna
making-
consider. You don't wanna
Are you
read it,
making- are
you
you
wanna
making a
disregard it, that's
judicial-
your choice.
are you making a judicial determination that you don't have to answer that question I just asked you, Your Honor?
Mr. Brooks, the COVID-19 protocol has been placed in front of you. It is your choice whether you want to review it or not. So my understanding, just from the information Mr. Brooks has provided, which is part of the public record, is he is requesting an adjournment of all proceedings due to learning that he's on a COVID-19 protocol. I don't have any other information than that, sir, but based upon, and again, I did I was provided with the COVID-19 illness reporting protocol. I wanted to make sure that I had the most recent information that at least the county of Waukesha is operating under. I also verified with court staff that the location at which you are seated is not within 6 feet of any other individual in this courtroom. Is there any other information you think I should know as I consider your request for an adjournment today?
Yes, I find it hard to believe that you couldn't consult with jail staff to verify the protocol, to verify that I was seen by nurses that
I don't have that
specifically.
information, sir, and let me be clear, cannot be provided to me under HIPAA. The only information I have is what you put in the inmate communication form.
It could be verified because I was told when I was brought down here that everybody knew that I was on a COVID protocol. That's why everybody
Because you advised us.
That's why, no, because the jail advised them. That's why they had to wear masks to bring me down. That's why I'm essentially on a protocol that doesn't allow me out of my cell until my results come back. So I'm not allowed out of my cell at the moment because of the protocol that the nurse himself placed me on, that the jail confirmed. That is very easy information to obtain.
Sir, I
Just-
have
just like-
an attorney for the
excuse me,
county
Your Honor.
here
I
who
don't-
will
I don't
verify
wanna- I
that
don't
none
want
of
you to
that
think I'm trying to
information
argue
has
with
been
you, Your Honor.
provided to me due to
I don't-
HIPAA
I don't want you to think I'm
requirements.
arguing.
So I'm not
But I-
arguing it with you,
I
sir,
know, I
one
just
bit.
want you to know that I'm not arguing with you either, but I was right in the middle of finishing what I was saying.
So I need to stop you for a minute, Mr. Brooks,
I don't
because
consent to that, Your Honor, because
you don't have to consent,
I
but here we
don't
go.
consent or agree to
Let me,
being cut off right when I'm trying
all right,
to
I'm just
provide
gonna
the
talk
court with
over him for a
information.
minute. I do not have any other information regarding, the COVID-19 protocol, meaning anything specific about you, Mr. Brooks, other than what was put in the inmate communication, which reads, due to just learning I'm on COVID-19 protocol, I respectfully ask for all proceedings to be adjourned at this time, which is why I asked you if there was any other information you wanted to provide me as I consider your request, because the jail has not provided me with any specific information regarding the reason you were placed on protocol, whether you were exposed, whether you are showing symptoms. They cannot provide me with that information absent you giving them permission by signing an applicable authorization to do that. Without that, I have to rely upon you to provide that information to me if you so choose.
That is incorrect, because just yesterday you were trying to obtain the witness list that was in my cell. You had no problem whatsoever having the JA come down here to have me verify that they can go in my cell and search for that. So I find it very hard to believe that you can't consult with jail staff for them to tell you what is going on in my situation, where they know that I've just been seen by a nurse that placed me on this protocol for having a loss of taste, fatigue, and I have to wait for the results of my test. And until then, I am on a protocol which restricts me to my cell. That is very easy information to obtain, and I find it very hard that Your Honor cannot obtain that information, but can obtain a way to communicate with jail staff when there's a witness list involved. We're talking about someone's health that can affect not just you, but anybody else, not just officers, but also inmates. We're talking about health, and we're talking about safety. That has a lot of merit. And frankly, Your Honor, I'm afraid. I'm fully vaccinated, and I've never had COVID. I don't know what I'm looking at here. That was the last thing I was hoping I would be told today, Your Honor. So I'm afraid right now. I'm not feeling well. I don't know what's going on with myself. That's the reason why I put in the sick call slip initially. I had been telling officers for days that I hadn't been feeling well, but I didn't know what it was. But I felt that I had to put in the sick call slip because I was not able to taste anything. That is the reason why I was seen by nurses. That is the reason why the COVID test was administered, and that's why I'm on the protocol as we speak.
Are you willing to discuss with me what tests were done? Again, I cannot obtain that information on my own.
I'm not a nurse, Your Honor. I don't know the name of the test. Like I said, I've never had this happen.
Let me clarify that. That was a pretty ambiguous question. So, you reported symptoms as that's what you're telling me, right?
Correct.
And you're saying some tests were done?
I mean, that it's obvious. I mean, why can't it be verified with the nurse?
I have to verify it with you. The nurse will not provide me with this information.
But the jail can, because they control the movement. They control all inmate movement. I can't just go from my cell to a HSU.
Inmate movement is not the issue at the moment.
It's not, but I'm saying, how can I tell you, how can I answer what you're asking me? It doesn't make sense. We all understand that the jail itself controls the movement of the inmates. That's common sense, Your Honor.
I'm not here to talk about inmate movement at the moment. What I'm asking you is, do you believe you were tested for COVID?
I obviously was tested for COVID. I would not be on the protocol if I was not.
Do you know
The
what
nurses-
type of test? Was it an oral swab, a nasal swab?
It was a nasal swab.
All right. Do you know when the results of that test will be back?
From my understanding, Friday. That's what I was told by the doctors. I would have to be at least on this protocol until the results come back, which
Were you-
he said the earliest would be Friday.
Were you offered a rapid test?
They said they do not do the rapid test.
So you weren't offered a rapid test?
They said they don't do them.
If one can be obtained, are you willing to submit to a rapid test?
I'm not willing to submit to anything right now until we take care of the issues that's at hand. I mean, I've already been placed on the protocol. Frankly, I'm very afraid right now because I don't know what's going on. This is new to me. Like I said, I'm fully vaccinated, Your Honor. I've been fully vaccinated since 2021. And so for this to just be sprung on me now to say this could possibly be a COVID thing, I've had people close to me that have passed away from COVID. I'm afraid as hell, Your Honor. That's the reason why I submitted the ICF for the adjournment. I was thinking at least until I can get the results, at bare minimum. I don't think I'm asking something that's
Sir,
impossible for
if
Your
I
Honor to
can
grant.
make arrangements to have a rapid test brought to you and administered, are you willing to submit to that test?
Not at this time.
Why not?
Not at this time.
Why not?
Why can't I get the results for the test I already took?
But you're telling me you're scared, you're
Yes,
fearful.
I am.
But you don't
very.
want to take a test that might
I
tell you today?
I took the test that he gave me.
And
if
you're
he
telling me
felt-
that test result won't be available to you until at least Friday.
At least Friday, that's what I was
So
told.
tomorrow.
I was told that I would be
So
placed
day
on this
after.
protocol until the results came back. The earliest that the results would be back would be Friday.
So that sounds like, to me, I think that's what they call a PCR test.
I have no idea, Your Honor. I
Okay.
have no idea what it's called. Like
Let
I
me
said,
ask
I've
you-
never had COVID. I don't know the test names. I don't know what they call them.
I'm generally familiar with some of the testing for COVID. There are tests that can be what we call rapid tests, or what are called rapid tests, that are available. And then there's these other tests which take a few days. Again, I'm not a scientist, but I think the general belief would be sometimes the rapid tests are accurate, sometimes they're not. Sometimes people test negative when they're really positive. It just kind of depends on the circumstances. But it's my understanding a positive test would be pretty accurate. And then there's other tests that take a few days for the results to come back. It really depends on the lab that's being utilized, etc. I'm asking you once again, if a rapid test can be obtained, are you willing to take a rapid test?
How would that be obtained? How would it be obtained?
I would
was
work
told,
with-
I can only go by what was told to me, because when I was brought in there and they told me that they had to test me for COVID, I was immediately like, what do you mean you have to even test me for this? What is this about?
Well,
I had
didn't
a
you
lieutenant.
report symptoms to them?
Excuse me, Your Honor. I had a lieutenant and 2 officers present when I was asking all these questions. Why do I need? What's going on with this? Why is this? Why is this? Why is that? Because I didn't understand. Immediately in my head, I started to get afraid when they said they had to even test for COVID.
Well, were you reporting being sick and symptoms prior to them asking you to test?
Yes, I've told multiple officers. I didn't know what it was at first because it started with fatigue, with me feeling very fatigued. And I said, man, I don't know if it's just me being tired, or that's what I initially thought it was. Maybe I'm just a little exhausted. But I said, no, anybody knows their body. I said, this got to be something more, because I'm really, 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 I don't even have an appetite. Then when I'm trying to eat, I can't taste anything. That's what said, okay, now I need to put the medical sick
When did
call
you
slip in.
report these symptoms to the medical people, or to even just a correctional officer?
A few days ago. Over the weekend is when I started to notice the fatigue. So I was telling officers, man, I don't feel good. I don't know if it's just I'm tired.
When did you-
Usually I don't just jump the gun and say something's wrong, because it may just be, it could be anything. So
When did you report the loss of taste?
I reported the loss of taste last night.
And was it after that that they told you they wanted to test you?
No, they didn't tell me till this morning that they wanted to test me.
What other symptoms are you reporting at this time?
That was it so far, just the fatigue and the loss of taste. Which is the reason why I was told that I had to take the test. Which I was told at that time also that the earliest my results would be back would be Friday.
And you said at this point you're not willing to take a rapid test.
Well, they said this is the test that they do. The nurse was very clear in what he was telling me when he told me how the test, because like I said, there was a lieutenant and 2 officers right there while the whole thing was going on.
I understand all of that. I have a very specific question to
I
you,
was
sir.
asking them questions, and he specifically told me that this jail, this is the test that they do. They do not do rapid tests. I didn't even ask about the test because I know nothing about the test. This is what I was told. And after he told me that, I said, okay, fine, just do the test and I'll just sit on the protocol, because at first when he told me, you know, you're going to have to be on a protocol where you're isolated. I said, okay, fine, just do the test. I'd rather you do the test and make sure that I'm healthy than to just refuse the test and just say, I'll just wait to see if I get better or something like that. So I said, yeah, just go ahead. And that's what I was informed. Friday would be the earliest that I would get the results back, and I would be placed on a protocol which is called isolation, where I'm not allowed out of my cell.
Anything else, sir, you think I need to know about this issue as I consider your request?
No, at this time, I'm just telling you what I know. Multiple officers were there that can tell you the same thing that I'm telling you now. Like I said, Lieutenant Chamberlain was there. 2 officers were there.
Any objection if I talk to any of them to confirm what you're saying?
Absolutely not.
Any objection if I need to ask the jail administrator about, or anyone else at the jail about, the protocols and what's available for testing?
Absolutely not.
Given any information about whether anyone else in the facility is experiencing COVID right now?
I wouldn't know that. I wouldn't know who. I'm in the mental health medical pod as it is.
So no information's been provided to you that there's like either a lockdown or some type of a restriction due to any like concern over COVID at this time?
I would never have that information, because like I said, I'm limited in the pod that I'm in. I have no interaction with any other inmates, and my interaction with staff is pretty limited.
All right, thank you. I appreciate that additional information. I know, sir, what I've provided to you is generally the, for employees, I fully recognize that the jail may have different protocols just because of it being in a correctional facility, and inmates are, of course, or can be very close to one another. And so I don't want to presume that this is exactly what they follow. And so I'd like for them to tell me what their protocols are as I consider this request. At the moment, I told you this earlier, you're not within 6 feet of anyone else in this courtroom. And I believe that provides ample protection for the other people in this courtroom. As I consider this request, you've provided information to the court. You've been able to tell me the symptoms that you are reporting, your understanding of the protocols, and despite you reporting fatigue, I know, I don't know if you're standing or sitting on the chair. I can't quite tell. It appears like you're standing, but maybe leaning over the table.
I got a knee on the chair.
Oh, knee on the chair. Okay, but you've been able to very clearly, coherently make your position known to the court at this time, and I appreciate that. Let me ask Attorney Opper if there's anything you would want to provide or state at this time regarding this request.
Yes, Your Honor, a couple of things. Number one, we believe this is nothing more than a further delay tactic by Mr. Brooks. I can advise the court, as an officer of the court and as an offer of proof, that he is.
How could
Mr.
that?
Brooks, did
how
you
could that
hear
even?
Attorney Opper interrupt you when you were talking?
Well, I respectfully object to
You
that.
can object, your objection's noted, but you need to let her state what she needs to state. I will give you an opportunity to respond. I'd
That's
encourage you to use
that is
paper and a
ridiculous, Your
pen
Honor.
to write down. That's the rules of decorum in the courtroom, sir. We generally avoid interrupting one another so that, number one, the record can be clear, and perhaps most importantly, because that is a sign that we all understand that this is a place of dignity, it is a place of respect, it demonstrates that, frankly, a willingness on the participants to conduct themselves appropriately. It avoids creating disorder or disruption. So I will give you an opportunity to respond, but you need to give Attorney Opper an opportunity without interruption. Go ahead, Attorney Opper.
Thank you, Your Honor. Your Honor, again, we believe this is a delay tactic in line with the defendant's behavior since about the August 25th or 26th motion hearing. I can advise the court, as an officer of the court, that Mr. Brooks has been saying for the last several weeks in his recorded jail calls to his mother and others that he's going to get this trial delayed or adjourned or pushed back. This behavior, again, on the 11th hour is 100% consistent with that. I believe that if the court wanted more information from the jail administrator, she is present and could provide that information. I believe Mr. Brooks has waived any HIPAA privacy rights he may have in that regard and indicated that to the court. And also I believe she would be able to provide information if the court ordered her to do so. I believe that even if he is on COVID protocol, it will have zero impact on his ability to prepare for this case. As we've learned already, and I'm prepared to make a further record, he has all of his discovery materials within the confines of his jail cell. He has a tablet made available to him in the confines of his own jail cell, and he has the ability to use a conference room in his pod. I don't believe the COVID protocol would interfere with his ability to access that conference room whatsoever. But again, I could verify that with the jail administrator if the court thinks that's an appropriate fact. The fact that he claims to have started reporting symptoms as far back as the weekend, we're probably right up against the 5 days right now. If he started this on Saturday, which I don't believe there's any record of, we're at 5 days right now. And certainly the court's offer to...
I never once said...
Mr. Brooks,
I never
have
said...
an
I never,
opportunity
no,
momentarily.
No,
You
I
need to stay
respectfully
quiet.
object to that because that has no merit.
Mr. Brooks,
I-
it's not
she's
your
saying-
time
no,
to speak.
No, I respectfully object. I never reported saying what day. I never said a day. And if you saying she's saying she has jail phone calls, well, why aren't they present? Why can't they be verified by sworn affidavit and brought into this court to be shown that this is a delay tactic, as you say it is? How come it can't be shown by sworn affidavit? Can you provide proof of that?
All right, Mr. Brooks, I've given you a little
Just
bit of
like-
leeway
just like you're
because we
saying
are outside the
that I've
presence
waived
of the
something.
jury.
I haven't given consent to waive anything. I've simply told the judge that I had no issue with her verifying with the jail that this protocol is in effect and that I was in effect tested for COVID-19. How could that be a delay tactic? if that was a delay tactic, why would I even need to be tested and placed on the protocol? Why does everybody have to have on masks to bring me down here?
All right, Mr.
Is
Brooks,
there no-
I've
is there
given
no
Mr.
verification?
Brooks, I'm going to warn you now that you have interrupted a couple of times. You interrupted
I have to
Attorney
be able-
Opper
I have to be
twice.
able to speak up,
You're
Your
now
Honor.
interrupting me yet again. We all were polite and had you provide
was not
information.
polite. That was
That's
abuse.
at
That
least
was-
the
that was
third
abuse.
interruption of this court.
That was abuse by the prosecution. That was abuse.
Mr.
To-
Brooks,
to
let me
sit- to
finish.
sit- No, because that's.
So
I
he
would
now
not-
he's
I would not
outright
sit here-
refusing to listen.
I would
He's
not sit
outright
here. I would
talking
not-
over
no,
me
I didn't
at the
refuse
moment.
anything. I didn't refuse
Mr.
anything.
Brooks, we are at
I'm
the
not.
point
I'm not gonna.
yet
I'm
again
not gonna. I'm not
where
gonna
I
sit.
will put you in the other courtroom because
And
you
I
are
don't
not
consent.
able.
I don't consent to being removed. I have not waived the right to be present, and I don't agree with that.
Mr. Brooks,
Does the
I
record
have
reflect?
provided
does
you
the-
on multiple occasions and it's should be in front of you.
No,
and
I
if
don't.
not,
I don't acknowledge that. I haven't agreed
you
to
have been
it, and I
advised
haven't
on
given
multiple
consent of it.
occasions that you need to abide by the standards of courtesy and decorum for the courts of Wisconsin. Because you are a litigant, you're both a named defendant, you are now acting as your own attorney by
I'm not a named
representing
defendant.
yourself.
I don't recognize the name
That all of the
the
rules
states
of courtesy and
put on
decorum
their
apply
complaint.
to
I don't
you.
recognize that name, Your Honor. That is
Supreme
not who
Court
I am.
Rule 62.02 details many of the requirements for courtesy and decorum. I've referenced a couple of them on multiple occasions, including that sub 1 sub F of 62.02, that proper conduct and attire is expected within the courthouse, and where possible, individuals, including yourself, right, are to refrain from creating disorder and disruption. Sub H, you're supposed to conduct yourself in a manner which demonstrates sensitivity to the necessity of preserving decorum and integrity of the judicial process. You have been advised multiple times, sir, of the expectation that this court has that you conduct yourself in a civil manner. You've been advised multiple times that this court will not tolerate disruptions, interruptions, that when you do that, you run the risk of forfeiting your right to be present in the courtroom. As you know, I have available the courtroom next door that's connected to the holding area. It is connected by audio and visual means. It provides you an opportunity to meaningfully participate by also giving the court the opportunity to control the decorum, to control the disruptive behavior, because primarily your disruptive behavior is repeated interruptions of this court, talking over this court, now talking over the prosecutor. I appreciate that you have not interrupted me for quite some time. So at this point, though, I need to warn you that further interruptions may very well result in you being removed to the other courtroom where you would participate by audiovisual means. At this time, I would like to hear from the court administrator, especially as it relates to the protocol.
Jail administrator.
Did I say the court administrator?
Yes, that's all right.
That's okay. We're in court, and I would like to hear from the jail administrator. Thank you very much. Just to get some general information and perhaps even some specific information regarding the what Mr. Brooks has provided, since he indicated I could verify all of this information with either the lieutenant or others who are present. So I believe we have Angela Wallenhaupt here, if she would come up to the witness stand.
Your Honor, if I don't want to mix issues, but the inmate communication form from September 28th also still needs to be addressed by the court, and I think the jail administrator may have some information relevant to that issue as well.
All right, Thank you. I
Please.
have a list of a bunch of things I want to go over, and I'm gonna.
So, Your Honor, respectfully, just so I'm clear, are we addressing the issue at hand now,
We are.
or are we addressing something from September?
Well, I will get to the September inmate communication form at some point during this hearing, but right now I'm addressing the most recent inmate communication form that is dated October 5, and that addresses your request for an adjournment. So I'll have you sworn in. I'll just do it. Raise your right hand. Do you solemnly swear that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Would you please state your first and last names for the record?
Angela Wallenhaupt,
Would you spell your last name?
Wollenhaupt.
Thank you. If you could please advise us on the record again of your job title and responsibilities.
I'm the jail administrator for the Waukesha County Sheriff's Department. I am head of the division in charge of all staff and inmate issues.
Could you provide information to the court on the general COVID protocol within the jail?
Judge, I would prefer to not speak to the operational considerations with that. I can speak to the fact that there are different protocols that are put on people for different medical or management reasons, which may have modifications to them. I can speak to the protocol Mr. Brooks has placed on, that it won't affect the area he is living in, nor access to areas that are not other inmate occupied.
That seems fair. I don't want to certainly put all of your operations on display. That's not necessary. But if you could speak to the specifics as it relates to Mr. Brooks's current situation.
So he would remain in his current cell housing location. He would have access to a conference room if he needed it, access to a telephone. And we would be able to, it's a safety security measure for him as well as our staff. And we can safely produce him for court.
When I hear the phrase being on a protocol, that to me could have more than one reason. Someone could have been exposed, someone could have tested, or someone could have reported symptoms that required testing. Would I be mistaken in any of those beliefs?
You are correct, Judge.
Would there be any other reasons for someone to be placed on a protocol, a COVID-19 protocol within the Waukesha County Jail?
No.
And would you tell me which one of those three options has prompted the COVID protocol for Mr. Brooks?
Judge, I have not reviewed his medical record prior to arriving here.
All right, fair enough. Do you have an understanding of what that is?
Yes,
Based
however,
on information provided to you?
yes, however, he has not signed a release allowing me to speak to the court. So if you are ordering me to speak to the court, I can speak to what my understanding is.
Mr. Brooks, I took your statements earlier that you would not object to me asking jail staff about the current situation to verify the information you provided. Is that still correct?
I said that I wouldn't have any issue with pertaining to myself. I don't know. I'm not speaking about anybody else in the jail. I'm not speaking about everybody's situation is different.
Right, and I'm specifically referring to your situation.
Well, the question was asked in, how does it pertain to me? It was pertaining to me, all the questions, which it came up when I said that there was a lieutenant and there were officers present when I took this test from the nurse.
Right, I'd like to verify the information that you're providing to me regarding what was reported by you, what tests were administered, and why you're on the protocol with the jail administrator. First of all, do you understand what I want to ask her about?
No, I do not understand.
Did you hear what I said just now?
I do not understand.
But did you hear what I said?
Frankly, Your Honor, I think she would probably be the wrong person to be asking because she wasn't present.
You must understand then what I'm saying if you think she's not the person who would provide that
No, I
information.
don't understand.
So,
I didn't consent to understanding or agreeing to that. No, I do not understand.
all right. I took his statements earlier. I realize you don't have a written waiver as to be a verbal waiver of any privacy rights under HIPAA, and I am directing you to answer the question.
Okay. It was brought to my attention shortly before the lunch hour that he had made statements that prompted the medical department to follow up. As I said before, I have not reviewed the medical record. It is my understanding he was administered a test. He was also offered another test, to which he refused.
Do you have any information regarding whether this other test would have been a rapid test?
I believe it to be.
Do you have those tests available in the facility to offer to an individual?
I have one available right now.
Can I ask a question, Your Honor?
Of me or of the witness?
Of jail administration.
Go ahead, you can ask a question.
Ms. Wallenhoff, if there were different types of tests available, why wasn't I administered the correct test when I first was tested? Why would essentially I would be asked to take a test, take that test, then turn around again and be told to take a whole nother test? In my mind, that's almost like some type of ploy or something, some type of scheme. Why?
Sir, what's the question?
I asked the question, why would I not be given the correct test from the get-go instead of having to take two tests? If I've already taken
Mr.
one
Brooks,
test,
you have to give her an opportunity to answer, and you
I've
gotta
already-
ask one question at a time.
I just asked the question.
Can she answer it then? Do you want her to answer it? I presume you do since you asked the question, so you need to stop talking so that she can answer it, okay?
Limit your abuse, Your Honor.
I'm sorry?
I don't appreciate being talked to that way, Your Honor.
Your objection is noted. Go ahead and answer.
Judge, I would prefer not to answer that question. He states the wrong test. I don't know what he's speaking of. I have not reviewed the medical record with what test was administered, so I would prefer not to answer that question.
All right, fair enough.
I did not say the wrong test. I said two tests. If it was, why would I need to take two tests for the same symptom?
Your Honor, I object to relevance and beyond the scope of this witness's knowledge, and it also assumes a fact, not an evidence.
All right, so I'll sustain the objection. I'll give both parties an opportunity to ask questions of this witness since it's Mr. Brooks's request. I know do you have any other questions for Jail Administrator Wallenhopt on this issue at this time?
I don't think I was clear, or I didn't have clarity on the answer to that question. Essentially, what I'm asking is, why would I need to take two tests for the same thing? There shouldn't. If I'm taking a COVID test, why would I need to take another one?
I'm gonna object as to lack of foundation and beyond the scope of this witness's knowledge, Your Honor.
The objection is sustained. I'll direct the witness. She does not need to answer that question. Next question, if you have one, please.
I still don't have clarity on that, Your Honor. I'm baffled.
Do you have another question? A different question?
Would it be any way to verify why I would need to take two tests for the same symptoms?
I'm not sure I understand the question, sir. I think
I'm referring to The nurse who administered the test.
The nurse isn't here, though. This is Jail Administrator Wallenhoft.
And that's why it's hard for me to wrap my head around why Mrs. Wallenhoff would be called to testify when she was not present. I think the wrong person is testifying.
Do you have any other
Because
questions
the
for
reason
her?
why I
I
say
understand
that-
what you're saying. Do you have any other questions for her, though?
Are you sure you wrapping your head around what I'm saying, Your Honor?
Do you have any other questions for this witness?
To your knowledge, you just said that you have a rapid test available right now. When did that become available? Because I was told otherwise.
I know there is a rapid test available right now. As I stated before, it is my understanding that you were offered a rapid test and you refused.
So why was I not offered a rapid test from the get-go?
Objection, relevance.
If she knows, she may answer.
I do not know the answer to that. I have not reviewed the medical record, jail contracts with a medical provider.
Thank you. Next question, if you have one.
So there are more than one type of COVID test administered by this jail.
Again, the jail contracts, Judge, I prefer not to answer that. The jail contracts with a medical provider. I do not direct testing for medical conditions. That would be our medical contract.
I believe the record's clear that a rapid test was offered. It was declined by Mr. Brooks. The record's also clear that
I
he did
object to that,
submit.
Your Honor.
He did submit to a test, but this witness is not able to answer whether that was a rapid or not, given her role in the Waukesha County Jail as the administrator and not in charge of medical. I will find she does not need to answer that question because it's outside her scope. And to further answer it might be speculative. So, do you have another question?
So would it be fair to say, you just said it would be speculative, so would it be fair to say that it'd be speculative that the second test would be a rapid test?
I will make a determination on your motion after all of the evidence and testimony on this issue is received.
Is that an answer,
I can't
Your Honor?
answer that question at this
Well,
time,
I'm
sir.
asking it of Ms. Wallenhoff. Is it because we just said it would be speculative?
Well, you
So-
were looking at me when you said that,
Well,
so are you, and I'm not gonna answer that question. I'm not a witness in this.
The
I
reason
make
why I
the
was-
determination
The reason why I was
ultimately.
looking at Your Honor is because
Do you have another question
I'm
for
still trying to
Jail
figure out
Administrator
how-
Wallenhoft?
I thought testimony was supposed to be the prosecution and the defense's time to ask
Sir, do you
questions.
have another question? Otherwise, I'm gonna ask the state if they have any more for this witness.
I asked the question, would it be fair to say that it's speculative about what the second test actually was?
Mr. Brooks, I don't understand your question.
What isn't to understand about it? If you were offered a test,
Objection, relevance.
no, it's a question.
Hold on.
I'm
You're
getting some-
asking a
I'm
hypo-
going somewhere.
I'll let you get the question out, but I would just note you're asking her a hypothetical that, given her role, she might not be qualified to answer. But you can go ahead and ask it.
Well, it's not hypothetical. It's very logical. If you were offered a test and you took it, why would you need to essentially take another test that could have been done right from the beginning? If there would be any issues, if there would be
All right, Mr. Brooks, it's not relevant what she would do. So that's essentially an argumentative
Okay,
question,
so why
and it's
would
not
I do it?
relevant. So
Why would
sit
I do it
down.
then?
You're done asking questions because you've
So
now
is that
asked.
a judicial determination?
I haven't made a judicial determination yet.
You're
Go ahead,
practicing
Attorney
law from the
Opper.
bench by being able to ask
Mr.
certain
Brooks.
questions of yourself.
Mr. Brooks, okay, here's your warning. I'm giving Attorney Opper an opportunity
So
to
you're
ask this
practicing law from
witness
the bench.
questions, and if you interrupt her, you will be removed to the next courtroom.
I don't consent to being removed to the next courtroom. I don't consent to even being at these proceedings if I'm not able to put on a proper defense, which is my constitutional right to be able to do so. I haven't agreed to any contracts. I haven't consented to any contracts, and I have
Your
not
objection
consented.
is noted. Attorney Opper, go ahead.
I have not consented
Thank you.
to
Ms.
an
Wallenhop,
estoppel either.
although Mr. Brooks is under a COVID protocol, is he still allowed to review his discovery materials in his jail cell?
Yes,
Jay, for relevancy.
To your knowledge, are those
Hold on.
materials?
The objection is overruled. Go
I'm
ahead.
sorry. To your knowledge, if you know, are his discovery materials currently in his jail cell?
yes, ma'am, to the best of my knowledge.
Okay.
I object to
Is
that,
he
yeah.
still
I object
able-
to that, Your Honor. I'm not allowed
Sir,
to
her
keep.
answer stands. There's no question to which to
I
object.
object to that. There is.
You can't testify at the moment. If you want to provide further information after she is done testifying, I will give you that opportunity.
Will she?
Your
will she be
objection
able to-
is
Will she
overruled.
be able to stay right there so I can ask the question?
It's not your time yet. You have to wait. So this is the final warning. Okay, I've given you a lot of leeway today.
You have not, Your Honor. You haven't. No.
I
you
am
haven't.
turning to Attorney Opper. It is her opportunity, her turn to ask this witness a question.
And it is my right to be able to object, just like she objected
And-
when I was asking
Right,
questions.
and when the court rules on an objection, usually the party who objects stays silent. I rule on the objection. The parties don't debate the ruling. It's noted for appeal. And then we move on.
Then I would like to put you on notice that I will be appealing that judicial decision that you are making.
Next question, Attorney Opper.
The judicial determination.
Ms.
rather,
Wallenhop.
that you are making.
While on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses. Is that correct?
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Yes, ma'am.
And nothing about the protocol would restrict his access to any of those materials. Is that correct?
Correct, ma'am.
And you've
I object to
indicated
that. I
previously.
object to that respectfully, Your Honor.
So, an objection goes to whether there's lots of rules of evidence that
That's it.
apply. But if you're objecting to her answer, that's a different thing. You can argue
I'm
the meaning
objecting
of
to
that
the
later.
question,
Okay,
not
the
the
objection.
answer.
But then you have to say objection before she answers. You
She
objected
didn't
after
answer.
she
She
answered.
didn't answer the last
The
question.
objection is noted, it's overruled, her answer may stand. Next question.
Ms. Wollenhop, you're aware that there has been digital discovery made available to Mr. Brooks for him to view in the Waukesha County Jail, correct?
I respectfully object to that.
Overruled, she may answer.
Correct.
He would view that digital discovery on the computer in the conference room in his pod,
I
correct?
respectfully object to that.
Overruled, you may answer.
Correct, ma'am.
And
So you're gonna
the proto-
overrule everything, Your Honor?
All right, Mr. Brooks, you have got to stop. It's fine if you object. I will rule on it as I deem appropriate under the rules of evidence, which, by the way, I provided a copy for you. See that big book over there?
No, I don't
It
see
has
it.
the criminal statutes.
I don't see it.
It has the traffic code. It
I
has
don't
the
see
rules
it.
of evidence. Well, it's on your table. It's
I
behind the
don't-
microphone, and it's there. I've provided it to you as a courtesy so that you have that available
you did not
to
provide
you.
anything to me.
Right, I'm
Something
directing the
that-
bailiffs to
something
remove
that
him
may
to the
have-
other courtroom.
something
I've
that-
provided ample
I've
opportunity for
never-
Mr.
I've
Brooks
never
to
taken
abide by the
anything-
simple
I've
rules
never
of
taken
decorum
anything,
and
Your Honor.
civility.
Your Honor, I don't
He is-
consent or agree to what you are doing.
Your lack of
don't give
consent is
consent.
noted for the
I
record.
don't give consent to an estoppel. I don't give
I'll make a
consent.
more full record when we
I
are
don't give
open
consent
again to
an
the public.
estoppel. I don't give consent to be removed.
Madam
being
Reporter, the
able
record
to
should
exercise
reflect
my
the court is
constitutional
stepping
right.
off the bench. You may step off.
I
if you
move.
want.
I move for a motion to dismiss. You still haven't even ruled on the claim. There's no one that even has a claim against me here.